Hi, I'm firearms attorney Gilbert Ambler, and we're back today to talk about how when you start beating the government in court, they're going to try to change the rules on you so that they can gain the upper hand. But before we dive into this subject, if you have not yet hit that subscribe button, go ahead, hit that subscribe button, like, comment with your thoughts, and share with your friends. That way you and your friends can keep getting this important Second Amendment related content. What we're here to talk about is the judicial conference that happened in March of 2024, happened this year. The judicial conference happens every 2 years in the United States, and during the judicial conference, 26 judges, including the Chief Justice of the United States, John Roberts, as well as judges from each of the geographic districts, as well as each of the Court of Appeals, get together and they set policies for the federal judiciary, for the federal judges out there. And this year, they adopted a policy that said if a suit is filed seeking either an injunction or declaratory relief against the government, that suit would not proceed in the division that it was filed if it was a single judge division, but would instead be circulated randomly among all the judges in the district. And we need to explain a little bit of how the federal courts work and why this matters for you to understand exactly what the Federal Judiciary Conference was trying to do. So, within a district, there are divisions, and those divisions might have 1, 2, 3, maybe even 4 judges. If you are able to file a lawsuit in a division that has only a single judge, then you know what judge your case will be assigned to typically. Now, what the government was unhappy about here was injunctions being issued on topics like firearms and abortion laws against the government. Because what was happening was people were starting to learn which judges were open to hearing their arguments, because a judge has to take on a sizable burden if he's going to enjoin a law that Congress passed. Or that an agency's trying to push forwards. And it's not an easy thing to get a judge to do, but there were certain judges out there that were willing to listen to these arguments. And so the federal judiciary, the judicial conference, said, we're no longer going to let people proceed in the division that they file. If it's a single judge division, we're going to circulate that suit amongst all of the judges in the district, which instead of just that one judge who might be sympathetic, might include 30 or 40 judges that you would then have a chance of having to hear this suit. And obviously the idea here on behalf of the government is that way these suits will not wind up in front of judges who are likely to enjoin the federal government. Now, here's why I think this is interesting. Number one, they're not doing this for all lawsuits. I mean, this is a concern. In fact, this concern, when it was originally raised about judge shopping, was raised in the context of patent law. So it was raised by a senator who was concerned about judge shopping in patent law cases. So they're not really worried about judge shopping in other types of cases. They're only worried about it when someone's trying to stop the government from doing something. Now, here's the good news. The good news is twofold. First, this will not stop relational cases. So often cases are winding up before the same judges because they are related to prior cases that judge has heard. So if 2 cases are very similar and a judge issued a favorable decision in a prior case, it is likely that you might be able to get the next lawsuit in front of the same judge because he already has an understanding of the topic, and so the cases might be related. So that's one way that a case might still go in front of a favorable judge, and you might be able to do that. The other benefit here is that the Northern District of Texas, where a lot of firearms decisions, pro-firearms decisions have come from, including from Judge Reed O'Connor down in the Northern District of Texas, the Northern District of Texas told the Federal Judiciary Conference where to shove it. Essentially what they said is this mandatory? And when the answer was no, they said, then we're not going to be implementing it. What does that mean? It means you can still file lawsuits in the Northern District of Texas. And I want to be clear with people. Just because you're in front of a judge who is willing to listen to your arguments does not mean that the judge is going to decide in your favor. It just means that there are certain judges out there that don't even want to hear the arguments, don't even want to hear that the federal government might be doing something wrong. You want to file in front of a judge that is at least willing to consider it, willing to entertain it, willing to hear the arguments, and brave enough to do something about it. If you enjoyed this content, go ahead, hit that like button, Subscribe, let us know your thoughts. Until next time.